Hello, my name is Jonathan Yuen, and today we are going to talk about GRID processes, or what we call Grievance Reporting, Investigative and Disciplinary processes. GRID processes address a set of very common issues faced by organizations. What happens when an organization receives a complaint about an act of misconduct or misbehavior? Is the act complained of even actionable to begin with? How should the complainant, or victim for that matter, be dealt with? How will the perpetrators be investigated or punished? How will the victims be cared for? Who decides what is the right or sufficient types and degrees of action to be implemented? What after-event follow-ups will there be? And in what cases should the authorities be informed? An organization's GRID processes must be seen to be fair, transparent, and consistent. People may not always necessarily agree with the outcome wholeheartedly, but if they feel that the organization has been open and objective, and the processes in managing the complaint have adhered to fair and transparent standards, it is more likely than not that they would be prepared to accept the consequences. Two cardinal principles must always be observed. First, the process must not be biased, and second, there must be a fair hearing. What this means in practice includes the following non-exhaustive threshold conditions. A. The complainant cannot also be a judge in the matter. B. The respondent must have an opportunity to understand the allegations and then respond to them or to contest them. C. Parties must be given reasonable time to seek legal advice should they wish. D. Any punishments doled out must be provided for in the organization's code of conduct, employment documents, and must be proportionate to the misconduct in question and be consistent with prior similar instances. And E. There must be a right of appeal against any decision at first instance. The whole point of these principles and in having a fair and transparent GRID process is to ensure that there is no premature determination of liability or the dismissal of the complaint until and unless a sufficient inquiry has been made, evidence has been collated and reviewed, all relevant parties have been heard, any mitigatory facts have been considered before an appropriate conclusion is made. And if disciplinary measures are necessary, then for the punishment to be in line with the law and relevant regulations. Disciplinary processes ought to clearly define the type of conduct that would constitute an offence actionable under its framework and the degree that would trigger corresponding consequences. In addition, the consequence or penalty must comply with the principle of proportionality. For instance, it would be very unhelpful to merely state that misconduct may result in disciplinary action without any further elaboration as to what type of misconduct or what degree of misconduct would trigger such a draconian consequence. Instead of stating habitually late and allowing the employee to argue that his or her lateness was immaterial or non-habitual, the organization can simply define lateness in its employment documentation to mean, for instance, arriving late at the workplace more than 15 minutes after the official start time, and to define habitual to mean any more than 3 times in a month. The investigative and disciplinary process should be carefully documented and interviewees should be required to initial their agreement to interview records, especially if these records are reduced to a summary. This is to prevent later allegations that the summaries were inaccurate. Where possible, these interviews should also be recorded so that a full transcript can be made available where necessary to verify what was said by whom and in what context. Recording interviews will have the benefit of not just protecting the organization, but also protecting the interviewee. If the investigators know that they are being recorded, the likelihood of them employing underhanded tactics or threats to coerce favorable responses from the interviewee will be significantly reduced. Ultimately, a good and simple rule of thumb to assess an organization's grid processes is to simply ask oneself, if I were to be subject to this process, would I feel prejudiced? Or would I feel assured and comforted that I would be treated fairly? Finally, in the event that the organization has to investigate a contentious, confidential or sensitive matter, organizations should consider engaging solicitors to manage the entire investigative process and to furnish a report to the board of directors or the disciplinary committee. This has significant advantages. First, the appointment of a credible and independent third party immediately lends gravity to the investigation, and it would be less likely that parties to the matter will complain of bias. Second, when solicitors are engaged, their work products, views and advice to the disciplinary committee and organization become subject to and protected by solicitor-client confidentiality. This means that in the event that a lawsuit is launched against the organization, and save in very exceptional circumstances, the organization need not disclose the details of the investigation to the plaintiff employee who is suing the organization. This affords the organization with an additional layer of protection when the matter turns contentious. Well, we hope you found this session useful. If you have any questions, do reach out to us.